making me speak after him. My talk is so dull compared to that. I can't top that. But good evening, everybody, and thank you, Professor. It's really a privilege being here with everybody in this room. And first of all, I want to say, how do I change it going forward? Okay. First of all, when you hear medico-legal pitfalls, you go, oh, that's the last subject I want to hear about because I want to practice medicine. I don't want to hear about this. This is very scary. There's an upswell of medico-legal litigation, whatever, and it's not bad. And my talk is not going to scare you. I think it's going to be reassuring because I must say that in my experience, the claims and matters we had to settle for urologists were not so much because of negligence, but because of lack of informed consent. So you can all relax. It's not about your technique, and it's not about causing an injury. There are known complications and risks, of which I'm sure you tell your patients about. But it's documenting it and making sure that you take proper informed consent. So the pitfalls that I'll be discussing very briefly will deal a little bit with how to avoid those pitfalls. So just to set the stage for negligence, you've all heard this before. The case of Van Wyk versus Lewis, very old case, just sets the standard of what's expected of you in private practice, which is that you must not deviate from the standard that can be expected of the reasonable urologist in your case. Now, that doesn't really mean anything to you. It just means you need to do your surgery the way that you've been taught. You need to tell your patient about the potential alternatives that's out there. It's not always surgery. Sometimes it's exercise. So you need to take proper informed consent and tell your patient about the risks that are unique to that particular patient. Every patient is different. Some patients present a different set of risks for you. So in the matter of Buthelezi versus Ndaba, it's also a case that MacRobert did. It was our Durban office. Went all the way to the Supreme Court of Appeal, where the court held that the mere fact that there had been that there had been a complication in an operation or treatment in a patient does not itself imply that there had been negligence. We call it's not a res ipsa loquitur. In other words, the facts don't speak for themselves. And I think there are many attorneys acting for patients out there who think, there's a bladder rupture, yay. Or there's a circumcision that's gone wrong. Or he poked a hole through whatever orifice. Oh, lekker, that's money for them. It's not the case. If you can show that you've done the surgery according to standard and that you've taken precautions to stay out of harm's way, and there's a known and expected complication in a case that was where the surgery was indicated, you can defend yourself against litigation. So what is the relevance of informed consent really? You hear it all the time. Take informed consent. Please take informed consent. It doesn't mean shoving a piece of paper in front of a patient and say, please sign there when she comes out. Mrs. So-and-so, you booked for surgery, sign there, sign there. What it does do is it helps me to defend one of those risks that eventuated. So you go in that morning, you scrub, you're all perky, you're married, you haven't had sex. You go in and you feel great, and the worst happens and you have a complication. I can defend that matter if the procedure was indicated, if you took reasonable precautions, and it's a known and expected complication, and you can show me that you've warned that particular patient of the risk and the patient consented thereto. It's as easy as that. The pitfalls are that there's no documents, or you say, I do that with all my patients, it's my protocol, but I don't write it down. We don't have time. We only have 15 minutes per consult, or 30 or whatever, and he was jabbering and I couldn't write it down. It doesn't have to be in writing, but what does help is if you can present me with a document saying the patient signed there that he received this information leaflet, or that I had discussed what was on the paper, because often the patients say, no, that wasn't discussed with me. The nurse brought it just before, and I'd already had my dormicum, and then I just was asked to sign there, and I didn't even read it. So matters that can be defended fall right there, because I can't refute that. And you say, well, I can't remember. My protocol is. So please help us in that regard. Consent needs to be free and voluntary. The patient has to give clear and unequivocal consent. I've already said consent needs to be fairly comprehensive, but it does not have to be reduced to writing. The patient does not have to have a paper, but it helps me prove what you had said. So second prize is having told the patient and made notes in your own handwriting, even if you use particular abbreviations. You can have little signs for bleeding. You can have little signs for perf. You can have little signs for adjacent organs, migration of whatever you can think of. You can have little signs. It won't take you longer than a minute to write that, and the patient's sitting right in front of you. So that's in your clinical notes. A written informed consent document is helpful because it also proves that the patient heard you and gave consent. Particularly pertinent in vasectomies, which is one of my pitfalls that I'll come to now. Use diagrams, use sketches. If you use a particular sketch always to explain a particular procedure, make the patient just sign there. It's not so bad. Shove it into the file. It will come in handy later. Internet links. Yes, of course, you can say to your patient, go and look there at www and so on. But it doesn't replace a personal consultation with your patient where you say, Mrs. So-and-so, now you've had many bowel surgeries, you've had a hysterectomy, no, not 4 hysterectomies, you've had 4 cesarean sections and a hysterectomy and tapes and all of that. So when I go into your bladder, might not be where it's supposed to be and all of that. So that particular patient might have a specific set of circumstances. So giving her an internet link as Tannie Griese walks out is not going to really help me to show why your insurer or indemnifier don't need to pay the bladder perforation, which leads to sepsis, which leads to ICU stay, which is R1 million. Vasectomy. So we all know with vasectomies, it's a 2-stage situation. You do your procedure the way you always do it. The patient is supposed to come back or go to the pathologist after 3 months to have a sperm test done to see if the vasectomy was actually successful. So very, very importantly there that you document that the patient was warned of this. I know you all warn the patient, but when I say no, waar is die papier? Then I I don't know, I moved practice, I went from paper to paperless, I had it somewhere, I always have it, there's one in the hospital folder, that's not the same as your one. So what I would like to see is one that says the patient acknowledges that he was asked to come back and whatever. These claims can get quite expensive because the unwanted child that's born from a successful vasectomy, not negligent, costs a child share of the combined household income. So each parent will get 2 shares and each child 1 share, and that unwanted child's value of his claim is 1 share of one of the children's lifetime maintenance that the parents would have paid, including university fees. So that is, if you ask why are subscription fees high, that is why. A simple piece of paper could have prevented a 2 or 3 million rand claim. So if you can have some kind of system, I know it's labor intensive, it's administrative, but you get all sorts of software these days where you could have a reminder. I don't know if you think it's feasible, but if you could diarize 2.5 months after a vasectomy, just a thing, the computer can do it automatically. You don't even have to write anything. It can just be, boom, reminder, you need to go for your sperm test. And if you can, save that to the folder or whatever, then it will stand you in good stead. So I've already spoken about that it can be very high. So vasectomy is probably one of the highest and most frequent that we see, where even with, successful ones, not even recanalization, just normal. Okay, another one, testicular torsion. Same thing. I know that mostly it's GPs who see the patients initially, or should probably, and the referral goes to a urologist if the GP realizes we're having to do with torsion and not orchitis. But the GP's notes and history taking is of utmost importance in the defense of the claim. If the patient has said, my pain started yesterday, and that note is there, I can almost say, I can defend that on causation, because we know blood supply loss, necrosis, etc. after 6 hours, before 6 hours, probably salvageable. Ne? Between 6 and 18, probably, possibly. After 24, so if a patient comes a day and a half, pain started day before yesterday, I want the note in the clinical folder. So now GP phones you, he says, oh, this patient has come back, I saw him so-and-so, and he wants to see, I think you need to see him, I think it might be a testicular torsion. Take the history again, please, because if that patient has the same story to you, he was playing rugby on Wednesday, he went home, he started having pain Wednesday, it backs up the GP's documents that says pain started Wednesday and he only went to the GP on the Friday. That matter is defensible because why? Testis would have been unsalvageable in any event, regardless of the GP saying, or people saying that the GP didn't ask the right questions. He didn't ask, are you sexually active? Is there a discharge? He didn't do a urine test. So even if the GP didn't test properly and didn't do a Doppler, it's still defensible because of causation. That's testicular torsion. Circumcisions. Adults, I don't have any particular advice except to say that maybe tell the person that it's not going to be like before. It's not the same. Something's going to be different. So don't expect that things will be the same. Might be a little shorter, psychologically only, but it might be a little skewer or whatever, but it's not going to be the same. Please warn of that, specifically in adults who seem a little bit too much interested in that part of their anatomy, because they can sometimes get very aggressive, which leads to uncomfortable situations in your practice. Children's Act, just quickly, the Children's Act does not prohibit children's circumcisions. I think the Act said that it's for religious reasons and so forth, but also for medical reasons, you can do a circumcision. Now, the testing and literature out there showing that the prevalence of HIV and sexually transmitted diseases are significantly reduced in males who are circumcised. We think that that is sufficient medical reason to say that there's a medical practitioner has recommended a circumcision in a child. This was interesting, cystograms in paraplegics, matter that we had. These are all matters that's gone through our offices. I don't know, a cystogram, the contrast dye is injected by the radiologist. Okay, but this is just interesting. The bladders of paraplegic patients have less capacity than that of a normal patient. Because of permanent indwelling catheters and frequent UTIs, the wall of the bladder is often weakened. So where the usual volume of a bladder might be 200 milliliters or such or whatever, and you would inject 200 milliliters contrast dye. In this particular matter, 200 milliliters had been injected, and when they replayed the video or whatever, they could already see the extravasation of the contrast medium. So the person had a bladder rupture, which led to septicemia, which led to a quite significant claim. So if you are sending a paraplegic patient for such a study, perhaps just chat to the radiologist who doesn't see that maybe that often. Patients like that do, I think, need quite regular studies like that. Harvesting of gametes, is that right, my pronunciation? Yes, you cannot harvest blood, tissue, or gametes from a patient who cannot consent specifically that the gametes can be used for artificial insemination. Otherwise, it cannot be used, and that is according to the Tissue Act, in terms of the Tissue Act. So if a wife comes to you, her husband's in a coma, you ask for the gametes to be harvested, you cannot do it. She must go and get a court order. Otherwise, it can't be used for artificial insemination. Just an interesting, and that's my song. Okay.